Excuses for non-performance. Conditions. Conditions are agreed upon limitations on performance in a contract. Performance is contingent on the occurrence of some event. Example, A agrees to buy B's car if B gets new tires. B getting new tires is a condition of A's performance of buying the car, indicated by words such as if, provided that, subject to. Condition versus promise. Failure of a promise leads to a breach. Failure of a condition relieves a party's performance obligation. Types of conditions. Conditions can be implied or expressed. Condition precedent. Condition must occur before performance is due. Non-occurrence excuses performance. Condition subsequent is a condition that occurs after performance has begun and excuses duty to perform. Purpose controls interpretation. Substantial performance of a condition may suffice if it fulfills the condition's purpose. Parties' intent controls. If a condition is clearly designed to protect one party, it will be interpreted consistently with that intent. A party protected or benefited by a condition may waive or stop the condition from being enforced. Excuse. Conditions may be legally excused by breach or repudiation. A party whose performance is subject to condition cannot prevent or hinder the condition's occurrence will result in excuse of condition. Insecurity arises when a party to contract has reasonable grounds to believe the other party will be unwilling or unable to perform under the contract. The insecure party may demand adequate assurances that the other party will perform and suspend performance in the meantime. This arises out of the UCC, but many states apply to non-UCC contracts. Demand for adequate assurances must be made in writing based on reasonable justified grounds for insecurity. No response required if demand is unjustified or unreasonable. If party is seeking adequate assurances is unreasonably insecure. Suspension of performance. A justifiable insecure party may suspend performance until adequate assurances are provided. Adequate assurances, commercially reasonable commitment from a party that will perform under the contract. If not provided, insecure party may treat contract as repudiated. Failure to respond to unreasonable demand is not repudiation. If adequate assurances are provided, the formerly insecure party must perform. Failure to do so will constitute a breach. Insecurity versus anticipatory repudiation. Insecurity involves uncertainty regarding the other party's performance, whereas anticipatory repudiation involves a clear indication the other party will not perform. Anticipatory repudiation, aka repudiation, arises when one party to a contract makes it clear that he will not perform under the contract. The effect is that it excuses performance by the other party. Requirements are that anticipatory repudiation arises if one party to a contract, 1, unambiguous act makes an unambiguous statement or conduct, 2, prior to full performance. So this is prior to the time the performance is due. And 3, indicating non-performance, which indicates he will not perform. So an example is A hires B to remodel A's kitchen. B is almost finished when A tells B she does not want the remodel and will not pay. B can treat the contract as breached, which excuses B's obligation to continue working. Note, distinguish from insecurity, which involves mere uncertainty regarding other parties' performance. Withdrawal. Repudiation can be withdrawn unless the other party has either 1, materially changed the position and reliance on the repudiation, 2, cancel the contract in response to the repudiation, or 3, indicated they consider the repudiation to be final. Non-repudiating parties' options. She may either 1, treat the anticipatory repudiation as total repudiation and sue. 2, suspend performance until performance date is due and wait to sue. 3, treat repudiation as an offer to rescind and treat contract as discharged. Or 4, ignore repudiation and urge promisor to perform. Then there's the impossibility and impracticability. If an unforeseen event occurs after contract formation but before performance is complete, performance may be excused as impossible or impracticable. Requirements are that an unforeseen event, which neither party assumed would occur, must make completing performance either 1, impossible, which is when performance is objectively impossible, or 2, impracticable, which is when performance is only possible with extreme and unreasonable difficulty or expense. Common unforeseen events. Substantial damage or destruction of contract subject matter. This is when damage or destruction must have been either party's fault. Death is when the contract obligations generally survive the death of a party unless the deceased party contract obligations are non-delegable. Usually only unique personal services are non-delegable. Subsequent law or regulation, which is a supervening illegality. If performance becomes illegal, excused by impossibility. Note, the MBE often uses the term impracticability to encompass both impossibility and impracticability. Then there's the frustration of purpose, which is a party's duty to perform under a contract may be discharged if an unforeseen event occurs that undermines or frustrates one or both parties' principal purpose for entering into the contract. The requirements are that K may be discharged if 1, an unexpected event destroys one or both parties' purpose for entering the contract. Whether performance is possible after the event is irrelevant. Issue is whether performance after the unforeseen event nullifies one or both parties' original purpose for the contract. 2, unforeseen event is not the fault of the frustrated party. And 3, the non-occurrence of the event was a basic assumption of the contract. Does not have to be stated assumption in the contract. Frustration of purpose versus impossibility. The distinction is that impossibility concerns duties specified in the contract, whereas frustration of purpose concerns the reasons a party entered into the contract. An example is a landlord rents a space to B, restaurateur, to open an ice cream parlor. If the property is destroyed by an earthquake, A and B are excused from performing due to impossibility. However, the city passes an ordinance banning the sale of sweetened foods. The contract's purpose is frustrated because A knew B intended to open an ice cream parlor.